In this short video, we're going to look at an evaluation essay on self-defence. Evaluation essays appear on exam 3, and you'll need to answer one essay on criminal, one on contract, one on tort. This is a criminal essay on self-defence. The question is, discuss the extent to which the law relating to self-defence meets the needs of the current legal system. As usual, it's worth 25 marks and you would have 45 minutes to answer it. I think this is a really interesting question because there's been a change in the law fairly recently with regards to self-defence and householders. And we have this very controversial case here. This is an image of Mr. Denby Collins, who was the victim, really, of the new law on householders and self-defence. So I'm certainly going to be talking about this in my essay. So if we scroll down to my suggested answer, as usual, my AO1 comments are in black font, my AO2 comments are in red font, and I've highlighted my Acts of Parliament and my cases for you. Remember that in evaluation essay, you get 10 marks for AO1, 15 marks for AO2. So you want to really pay attention to your AO2, make sure that you're evaluating the law, not just stating what the law is. So in my introduction here, I've said that it's been a long-standing principle of English law that a person's entitled to use reasonable force in self-defence or defence of another. Straight away, I'm into some evaluation there by saying that it's universally accepted in common law jurisdictions as a complete defence to all crimes. And unlike a lot of other defences, self-defence hasn't been called for restriction or abolition. And I've put it may be due in part to the romance, if you like, that this idea, an Englishman's home is his castle. This idea that you should be able to use force to protect yourself. And it's this sort of idea which I think has sort of led to some recent unnecessary changes to the defence. So that's quite a nice little opener there. I've then, of course, gone into where we find the law on self-defence. So the law on self-defence originated in common law, but it's been put into an Act of Parliament in the Criminal Justice and Immigration Act, and we've got the Criminal Law Act on prevention of a crime. Two key elements to the defence. Firstly, the force must be necessary. Secondly, the force must be reasonable. I'm going to explain each one of these in turn, evaluating as I go. So firstly, whether the force is necessary is a question for the jury. And it's whether the defendant believed he needed to use force in self-defence. I've used Hussein and another 2010 there, because if you remember in that case, the defendant and his son beat up somebody when they were fleeing. In that case, they couldn't have self-defence because force wasn't necessary because the person was already running away. That's clearly a fair decision because the law obviously shouldn't be condoning revenge attacks in any way. So contrary to what the media would have us believe, the defence has actually always been favourable to defendants. A defendant can rely on the defence of self-defence even if he makes a mistake about what was going on. So if I think people are having an argument and I need to use force to break it up, or I wrongly think someone's attacking me, I can use force and claim self-defence, even though that wasn't what was really happening. And the key case on that is Williams from 87. And in that case, the defendant thought that a police officer was attacking somebody when in fact they were making an arrest. Self-defence was still available because, as you can see there, a mistaken, unreasonable, but genuinely held belief for the need for force is enough. A little bit of evaluation there that it seems a bit strange that you're allowed to make a mistake, but you still have to be using reasonable force. I am pointing out, though, that whilst the defendant is allowed to make a mistake, if he's drunk, he can't use that as a reason. So if the defendant's mistaken belief is due to voluntary intoxication, they got themselves drunk, then they won't be able to plead the defence. Some say that's a bit harsh, but on the other hand, of course, it's not in the public interest for people to be getting drunk in order to escape liability. So that's part one, force must be necessary. Part two for the defence is that the force used must be reasonable. And this has to be judged by the circumstances as the defendant believed them to be, even if, as I've said, he was mistaken. What's going to be classed as reasonable will depend on the circumstances of the case, but Section 76 reflects the rather famous words of Lord Morris in the case of Palmer. And in Palmer, Lord Morris said, "A person who is being attacked should not be expected to weigh to a nicety the exact measure of his necessary defensive action." Not expected to weigh to a nicety. That's meaning that the law recognises that in the heat of a moment, where you're being confronted, you're terrified perhaps, you're not expected to weigh up exactly how much force you need. So a little bit of leeway is given. And of course, that's favourable to the defendant. There's also no duty for our defendant to retreat. That comes from Bird. So you're not expected to run away. You can stand your ground. And a defendant might even be able to claim self-defence even where preemptive action is taken, AG's reference. So that means that you don't have to wait for the person to strike the first blow. If you think someone's about to attack you, you can punch them first. Again, very favourable to the defendant. You could argue a concern here is that allowing this could result in vigilante behaviour, people taking the law into their own hands, perhaps. And force can still be reasonable, even where lethal force is being used. So even if somebody is killed, we can still potentially use self-defence, as long as the force was reasonable. And that comes from Beckford. Beckford was the police officer who received incorrect information that the victim was armed and dangerous. So the defendant police officer shot him, killed him. He was mistaken. The person wasn't armed and dangerous at all, but the force was reasonable and necessary in the situation he believed he was in. That's very favourable to the defendant, and it does seem to conflict with how the media represents the law. The media always seems to portray the law as being really harsh on poor defendants who aren't allowed to use any force. And of course, we can see here that simply isn't the case. The only restriction on self-defence is that if the defendant uses excessive force, too much force, the defence will fail. And there's no halfway house. That's a quote from the case of Aaron Clegg. So what that means is if the defendant uses too much force in self-defence, the defence fails because it's a complete defence, it's all or nothing. Some people argue that that's very harsh on the defendant, and perhaps if a defendant who's used excessive force, rather than losing the defence completely, perhaps it would be better for them to have a partial defence. Further problem here with the all or nothing nature of the defence is that statistically, women are less likely to be able to plead the defence successfully, particularly if they're suffering from battered women syndrome. And the reason for that is that, generally speaking, women and women with battered women syndrome are generally physically weaker than their abusers, who are men, typically bigger than them. So women, people with battered women syndrome, will typically pick up a weapon because the person they're frightened of is a lot bigger than them. And of course, the danger is as soon as you pick up a weapon, it can start to look like the force is excessive rather than reasonable if the other person is unarmed. So all or nothing is a bit harsh on women in these situations. Some argue we should follow the USA on this and allow more force to be used by battered women, but there is a danger, of course, that that could start to look like revenge attacks also. When looking at whether force use was excessive or not, the defendant can't argue and say, well, I know it was excessive, but I'm paranoid. And that was exactly what the defendant tried to do in Tony Martin. In that case, it wasn't relevant. We couldn't take into account his paranoia. The media, of course, has portrayed this case as particularly harsh. But remember here, the defendant did essentially execute people who were running away from him. And he did, in fact, successfully plead the defence of diminished responsibility because he was paranoid. So contrary to the media's portrayal, I don't think it was a harsh decision at all. So what we've seen in the essay so far is that it's very favourable to defendants. But despite the apparent fairness of the law, the media has been very critical that homeowners are not able to use sufficient force when they're protecting their home from burglars. I mean, that's not true. We know already you can kill somebody as long as it's reasonable in the circumstances. But despite that, we've got this media panic about it, particularly in the case of Tony Martin, that really interesting case. More recently, an intruder, Henry Vincent, was killed by a householder. Conservatives decided that a new law was needed regarding self-defence used by homeowners. It has been criticised massively. In the opinion of the secret barrister, the idea was described as, quote, as poor in execution as it was stupid in policy. And he's written a really interesting article on this area. Despite the worries about changes to the law, it was put into place, and we now have the Crime and Courts Act 2013, and that has amended the Criminal Justice and Immigration Act, which means that householders have they can use greater force than a normal person. They can use self-defence as long as force was not, quote, grossly disproportionate. Critics have argued that this change to grossly disproportionate force could encourage revenge behaviour, sanction extrajudicial punishment. Paul Mendel QC made some lovely points, I think. He said that the law should always encourage people to be reasonable, not unreasonable, proportionate, not disproportionate. And of course, this law doesn't do that. Michael Wolkind QC described this new test, grossly disproportionate, as, quote, horrible, and said, quote, it sounds like state-sponsored revenge. And I would have to say that I agree wholeheartedly with that. The new defence wouldn't have assisted Tony Martin in any event because, as I've said, he executed people who were running away with an illegal sawn-off shotgun. So people who were outraged about this case wouldn't be particularly happy that the new defence doesn't help him anyway. This new disproportionate force might also pose a problem with what if it's a borderline case? They're not quite in the house, they're at the exit, they're at the entry. There can be lots of difficulties there. We've then got the really controversial case. We saw the image at the beginning. Denby Collins and Secretary of State for Justice, 2016, where Mr. Denby tried to burgle a house. He was tackled and put into a coma by the householder. Sadly, he's still in the coma. Denby's father challenged this new householder's right to use disproportionate force, but unfortunately the High Court said it wasn't incompatible with human rights. But despite their decision, this case certainly illustrates the controversy around the area and the potential, I mean, I'm being quite dramatic here, but I do think there is the potential for torture, potentially, of householders to be entering through the back door, rather ironically. So I'm wrapping up in my conclusion here and saying that many people assert that the law on self-defence was satisfactory before the new householder defence, and that actually the Conservatives were attempting to fix something that wasn't broken as a result of a moral panic started, quite frankly, in rags in the media. And the law allowing grossly disproportionate force is vague. We don't really know what's grossly disproportionate, what isn't. It strays dangerously close to revenge for my likings. And in my opinion, in order to improve the law, it should be returned to its state pre the Crime and Courts Act to avoid more cases like Denby Collins.